NACDL is the association of the nation's criminal defense bar.
So, a few years back, and this was actually not long after I read Kathy's book, we were Weapons of Mass Destruction. We were talking about this algorithmic decision making and how it was showing up in the criminal legal system. And what it looked like to us is, if you've ever seen the movie, right, is Minority Report. Like, there's a pre-crime unit that's going to tell you where to go police and who to go police and who is about to commit a crime or where a crime is about to occur. And if you saw the film, it sounded like some kind of fantastical sci-fi thing. But some people figured out, well, this actually might work to our benefit. We can monetize this, and started to roll out what at the time was called predictive policing softwares. So for NACDL, we put together a task force. Hanny was actually on the task force. We had, I believe, 6 task force members. We went to 5 cities. We spoke with 50 witnesses, including Kathy O'Neill. We spoke with everyone from statisticians and mathematicians to community groups, organizations. We talked to defense lawyers. We talked to law enforcement. We talked to companies. We talked to everybody we could possibly think of. And so the result was the report that NACDL put out in last September, which is Garbage In, Gospel Out. That's where the title came from. How data-driven policing technologies entrench historic racism and tech wash bias in the criminal legal system. And so I'm not going to spend a lot of time talking about how algorithmic decision-making can do that, because I feel like Kathy set that up for us very nicely. But what one mathematician told us is it's not magic, it's just math, right? And the math can be really wrong. Also, just a word on why we used data-driven policing. But the use of analytical technologies to identify targets for police intervention in order to deter crimes or solve past crimes. But the reason that we use this statement, this term in particular, is because if I've learned anything through all of this, is all they'll do is shift, right? If you catch up on one thing, they shift to another thing. So from data-driven policing, they said, we're not doing that, right? In San Antonio, we're doing intelligence-led policing, totally different. And then, if you move on to NYPD, they're doing precision policing. Again, totally different, right? And so, they just changed the terms. And then if you talk to a company called Palantir, they describe themselves as data analytics, right? They're not predicting anything. They're just doing data analytics. It sounds very benign, because wouldn't you want the data analyzed? Sure you would. But this is what they promise. They promise technological infrastructure, that because technological infrastructure has failed, they can create clarity and order. Again, why wouldn't you want that? Clarity and order. But to deliver, and this is the key term, its software needs data, lots of it. And this is where we get to some of these companies. And so under the idea of predictive policing, you have some companies that were working with the idea of location-based policing, right? Trying to predict where you should put cops on the street. Some people would say this is CompStat on steroids. As Kathy pointed out, this is basically helping police where they've always policed. But one of the original companies was called Predictive, and they were based off of a model of how people predicted earthquakes, right? With the idea that if there's one earthquake, there's going to be more nearby. I will say in the course of our task force, we talked to actually someone who was an expert in the earthquake model, and apparently it wasn't great at predicting earthquakes by itself. But when you tried to take it to predict crime, it got even worse. Another one was Hunch Lab. So with Predpol, they always said, well, we don't do drug crimes because that's biased, and they only worked off of calls for service, right? So it's objective, because it's not the bias, where did police arrest someone because they stopped them, but where did someone call and say, my car was broken into, or somebody just stole my wallet. So they got reports of crime, and they said that's how it was, it was going to be benign and not problematic. Hunch Lab was another one that tried to be more open with their algorithms and what they were doing, put a lot more information in the mix, but again, the same idea. They weighted it differently, so they basically, if they took a big box, they said this city, there's an 80% chance of something happening in this part of town, a 10% chance over here, a 5%, a 3%. They would all get sort of if you think of it as one of those bingo wheels. For each percentage point, you get one little ball in there, so they might pick up the part of town that's 5% versus 80%. Well, those are some of the companies that were out there. And the next thing they looked at, I went a little too far, was people-based. And Chicago was ground zero for people-based, right? And this was the idea that you could predict either, in their minds, who was going to commit gun violence or be the victim of gun violence. Now, the person who originally came up with this idea, the idea of it was to think about where were the most vulnerable communities and source them with resources. You'll be shocked to hear when the police got a hold of it, they did the exact opposite. And so the people that they identified through, again, had they been arrested before? Did they associate with people who've been arrested? All the things that would lead them to police the same neighborhoods repeatedly. It turns out that if you end up on their strategic suspects list, you're more likely to get arrested. Again, the pivot when when they did their own sort of internal audit and turns out really didn't work, was they said, okay, we're not doing that anymore. We're doing the Subject Assessment and Information Dashboard. And this is what we see all the time. So LAPD, which was an early adopter of all of these technologies, including Predpol and others, and Palantir, and originally they had a program called LASER, which is the Los Angeles Strategic Extraction and Restoration. I'm not exactly sure how they came to that. Which had a chronic offender bulletin, sounds a lot like a strategic suspect list. Again, they had an internal audit that turns out these things don't work and are kind of biased. And so they said, oh, we're not doing that anymore. They are now doing data-informed, community-focused policing. The reason I'm going through this is because, again, we're finding the same programs sort of reformulating themselves with different titles. Because one of the things that's been consistent, whether you're talking about the LASER program in LA or I keep having a look at it, data-informed, community-focused policing, one of the inputs is their field interview cards. And if you know anything about LA, that's every time they stop somebody and question them, they fill out one of these FI cards. That goes in the mix so you can see how they continue to loop. And then, of course, you have Palantir, who's, again, just doing data analysis, but what they do is they end up doing social mapping, right, and deciding who's connected to who in what kind of ways. And this is an example of what they would draw to look like. Like, did anybody watch The Wire? You remember how they kept putting on the bulletin board and connecting to the next person? Well, Palantir, if you give them, as I said, lots of data, that's what they're going to do for you with your information. Now, when it comes to these things, one of the reasons I say, don't get too attached to the companies, to the names of the programs, to how they present themselves, because they are shapeshifters. So Predpol is no longer Predpol, because it sounds a lot like predictive policing, which has kind of fallen out of favor. So they're now Geolytica, right? Why that? I don't know. Interestingly enough, they took some of the same past blogs and other information and just kind of wiped out Predpol. They didn't cross it out exactly, but they just inserted the new name. Same thing with HunchLab. It got sold and is now ShotSpotter Missions. So earlier this morning, you heard about ShotSpotter and what a bang-up job they do at predicting where gunfire is happening. The other thing to understand is these things all work together, right? So they're telling you they can locate gunfire and send the police there. They can also apparently locate where crime is happening and send the police there. So you never find these things working in isolation. And then if you're Palantir and some, well-meaning organization of criminal defense lawyers puts together a task force and puts out a report and cites a bunch of your pages on how you help law enforcement, you just wipe it off the internet. It's not there anymore. I regret the fact that we didn't save those pages, but you just don't talk about it anymore. So you can find now their Gotham program on their website, but it has almost no mention of local law enforcement. They talk about it only in the context of military, which they do a great deal of military work. The other thing that goes hand in hand with these kinds of analysis of where to police and who to police and how to draw this network is social media monitoring tools, right? And there's a lot of ways they do this. So the first thing you need to know is how many laws there are in the United States regulating your consumer data. Guesses? There's none. Really none? Not at all. And that should concern you because, as Palantir said, we just need a lot of data, but you got nothing when it comes to regulating that data. And this is why that's important. There's a number of ways they can go about collecting your information, and there is always a new company that's going to come do it. There was a lot of press at one time about a company called Geophidia that was scraping that was basically going to law enforcement and saying, we can go through social media and let you know where people are demonstrating and who's talking to each other, and it got really bad press. Geophidia has gone away, but there's always a new company. So Shadow Dragon in Massachusetts, new company. And I'm going to tell you now, does it stay around? Does it do anything? I don't know. The point is they keep popping up, but you have to understand sort of what they're marketing to law enforcement. And so Shadow Dragon tells us that gangs use social media to talk about their disputes and sort out affiliations of who's in and who's out. It sounds a lot like criminals use their phones, right? Gang members use their phones to commit crimes. So therefore, we got to search all of their stuff. One of the things that the local U.S. attorney there was saying that, the poor officers were back in the dark ages when they actually had to scroll through and do the investigation themselves. And this is actually what I want to talk about in terms of a qualitative difference, not just a quantitative difference. So if you think back to the Carpenter decision, they said one of the things about this kind of cell phone tracking is it's quantitatively different, but it's also qualitatively different, right? It can run down everything in a very short period of time. You can go through and track all the movements of someone you never thought you wanted to track before. Well, that's exactly what they think Shadow Dragon will do for them, right? It's going to accelerate the process. What used to take a week or months might now take you a day or a few hours. So now they have the ability to go through that in just a matter of hours, maybe less. So they don't have to go back to the dark ages of looking it up themselves. Going back to the LAPD, who we know likes to use everything. So they're a firm that they partnered with. This is part of what they're trying to sell that they can do, that based on artificial intelligence calibrations, they can allow for a result within minutes that does not require any intervention or assessments by an analyst or an investigator. So what this means is they're marketing tools to go through social media and make determinations about your potential clients that no one has to review. So now they have huge stores of data that they can run through without being questioned and make decisions for you to, this one is looking at terrorism and radicalism online, but to make decisions with no human intervention. This should frighten you. It frightens me. So is that all they say it can do? No. They actually said they can conduct a sentiment analysis to discern who was most emotionally invested and had the passion needed to act on their beliefs. So again, this is the kind of thing that's being marketed to law enforcement that is then feeding, where do they police? Who do they think should be policed? How do they draw their social network maps? And when you move on from there, you have to understand that, even if you just don't have these companies, even if law enforcement has gotten past the dark ages of having to scroll through social media or figure out what's available online, even if there's something that law enforcement can't legally access, it turns out there's data brokers who know how to monetize this. And I will tell you, data brokers don't care why you want the data, right? You could be trying to advertise to people, you could be trying to criminalize people. They're just invested in, they can go out on the internet and scrape it for everything available publicly. All the photos, any kind of public Twitter accounts, any kind of public social media posts, any way they can draw people together, they will go get all of that and package it and sell it to anybody who wants it. And that includes law enforcement. And if I told you to guess how many laws regulate that, none. Not at all, not a single one. And so what they're doing is then taking that information and feeding it all into these systems that are then not just looking at your client and their direct or actual behavior, but who your client is affiliated with and how do they consider an affiliation. It could be anything. You could be, friends on Facebook. And if you're not on Facebook, maybe you're connected on Instagram. You liked their post. You commented on a post. They may use things like people who, I don't know, post song lyrics, and this has happened, right? But they post song lyrics, and then they use that as evidence of criminality. And so these are some of the ways that these things are pulling together massive amounts of data, funneling them through systems that can organize them, that can interrogate them, put out a package and say, here you go, law enforcement, this is what you need to do. And that the end result of that is your client being charged. So how do you figure out what's happening? What are some of the flags that make you say, I need to look into what they were using? I need to know why they were policing this neighborhood. I need to know why they were visiting my client's house, right? I need to know why they think that my client is connected to this gang or this crew. One of the flags is that there's a significant gap in time between the thing that happened and when they actually arrest for it, right? Sometimes we hear it could be 6 months, a year and a half later, someone is getting arrested for something. Your client may say, yeah, I did this a year and a half ago. Why is there that gap? What has happened in between? That can be a flag. A second flag is if in the context of your case there's an allegation of gang or crew membership, and they don't distinguish. And if you talk to clients who've been alleged to be one of either of those things, they will distinguish, right? Your crew is the block you live on, is the people you hang out with. There's no formalized structure. You're not, brought into it in any kind of way. There's no hierarchy. You're part of a crew. This is who you live with. That's your block. Versus a gang, which has a more formalized structure. They don't distinguish, right? Sweeping conspiracy charges. We're seeing this a lot. We saw it happen in the Bronx where they arrested 120 people, off of one shooting on these broad conspiracy charges. So when they start to draw these social network maps and figure out who's connected to who, they're essentially finding the one or two incidents and then charging everybody with just layers and layers of conspiracy charges. And the last one is if you find social media activity as evidence of relationships, activity, or intent. It can be any one of those things or all of those things. And so now that we're at the place where we know that data is everywhere, it's being gobbled up, you have no protection, there are companies that are ready to package it, make it shiny, name it really cool things, and then pass it off to law enforcement. Where does that take us? We're in full tin hat mode. Big Brother is real, the pre-crime unit is real, and now you've got to figure out how to defend your client.
All right. Well, with the tinfoil hat guy and a cat, is the best introduction I could ask for, right? So we're going to shift gears a little bit here, and this picture will make sense in a minute, but I thought it might make sense to take stock of what we've learned about in this, almost 2/3 of the way through the day. We've heard a lot about data and about the different tools that the cops use. We've probably all walked in here maybe having some idea of what that looks like in a criminal case because the U.S. attorney or the state's attorney calls you up and says, you need to send me a hard drive so I can produce all the discovery I have in your case. And I've got a forensic cell phone dump and I've got a 500-page CAST report for cell site data, and I've got your client's entire Facebook and Instagram account and PDF form, which is a billion pages, and it will crash your computer if you try to open it. So we're all bombarded as defense attorneys with tons and tons of data discovery, and we've heard throughout the day not only how the cops collect this data, how expansive the data is. We've also heard about a lot of the problems with the data and how it perpetuates a lot of the same problems that have long existed in the criminal justice system. And I think we need to take a step back and realize, why is it that there is this explosion of data? And I think there's two reasons for it. One is it's extremely useful, obviously, for the cops, right? We are all walking around, my cell phone's charging over there. We're all walking around with cell phones and tablets. We've put everything on the cloud. There's just so much more information about us that is available to law enforcement. I'm getting, I used to work in the Federal Public Defender's Office, and I would get cell phone dumps in almost every run-of-the-mill drug cases. Where it wasn't, I'm looking at pictures of my client with their kids. I'm looking at all the text messages he's sent and the games he played on his phone. And it just seems so beside the point. But there it is, right? And that's a routine part of it. So obviously there's some utility to it. But I also think that part of what is going on is law enforcement agencies are trying to convince the public and convince lawmakers and policymakers that, look, we don't want to be racist. We don't want to have our officers on the field being racist because we're not racist. It's bad for our 1983 settlement budget. And we aim to serve and protect. And so we're going to let the data drive us to where we should go. We're going to let the data make the decisions, and then nobody can come and criticize and say, well, the Chicago PD or the LAPD or the SFPD or insert any acronym PD is racist. And so what we've heard about today is about a lot of the flaws in this technology. And I think it's not just that the tools are flawed in the sense that they don't do what they purport to do, like ShotSpotter. That was very fascinating. I've had ShotSpotter in cases, and I learned a lot. I've learned a lot that I'm going to take home with me. We just heard Kathy talk about a lot of the problems with purportedly neutral algorithms and how they can reinforce biases. And we could talk for another hour about that. So I want to start with that table setting, because what I'm going to talk about is actually not really at all about data. I'm going to talk about this very boring subject known as the law. And I think, and what I hope is, with that understanding of that background, we can start to think through, well, look, the reality is, notwithstanding all of the flaws, notwithstanding all of the criticism and the real privacy concerns about the accumulation of this data is here to stay. People are going to have cell phones. People are going to post stuff online. Maybe people are becoming more sensitive to their privacy. You see a lot of these billboards up for Apple, and they kind of are bragging about how they're the pro-privacy company. I don't know about that, but I was walking down Michigan Ave yesterday, and there was a sign, and when I was driving to the airport in San Francisco, there was a huge billboard after you get off the Bay Bridge that says, the privacy company, whatever. So, notwithstanding all of that, the data is here, and the cops are going to get the data, and they're going to use the data. So and the reason I'm having this slide to start my remarks is to say, we got to be, as defense attorneys, we also have to use the data, and we have to use it as a sword. And I feel bad, I don't remember her name, but the public defender from Maryland who was talking about just how taking what the cops gave her, what the DA gave her, to dissect that data and pull out problems with timestamps and the fact that it's just, that's a perfect example of it. I'm going to talk about 3 other ways that we can use the explosion in police data as a sword in pretrial motion practice. Because the reality is the data is here to stay, and we might as well use it to our advantage. And so that's sort of my central thesis for this afternoon. And we have to start with the first kind of foundational point is, well, how the hell do you get the police data to begin with? What kind of police data are you talking about? And, there was a lot of discussion about subpoenas, and I won't belabor the point on that. I think everyone knows how to use a subpoena, but I want to start by talking about you can actually get a lot of police data online today from this. While you're sitting on your computer right now, you could probably go get some police data for free. What do I mean by that? Well, there's this, under President Obama, he convened this 21st Century Policing Task Force. And one of the recommendations of that task force was more and more police departments and municipalities as a general matter should have what's called open data. And open data is the idea that cities should make available to the public data sets pertaining to relevant pieces of information. And one data set that you will find in a lot of major urban areas is basically police calls for service. Okay, and you can go online and download in your municipality, not in every municipality, but in a lot of the really big ones, you can go dig around online and you can find posted their calls for service. I put up this website, the Police Data Initiative. This is like a great place to start to look to see if your city has police data online. Here's a list of a couple cities on this website that have police data online. So I'm from the Bay Area, so San Francisco. We'll talk about San Francisco in a minute. I'm going to show you a specific example of what this looks like. Do we have any lawyers from Texas in here? No? One. Okay. So the city of Dallas, has an open data portal. You go to this website, Dallas Open Data, and then you can get all of the Dallas Police Department's calls for service information, which we're going to unpack in a minute. The only reason I have Texas up here is because I gave this presentation, a variation of this presentation to the Texas Criminal Defense Lawyers Association. So, well, let me see what they have in Texas. And it's like, oh, Dallas has this data. Austin has this open data. And I'm sure in your state and in your jurisdiction, this data exists. If any major metropolitan area in the Bay, in California, in the United States, you see where I'm coming from, in the United States has some variation of this data. Let's look through what we're going to use Austin as an example because I already had the slides made. I'm kind of lazy. I wanted to keep it easy for myself. So what do I mean by calls for service data? So this is an example of what you can get online sitting right here in this conference room today. And if you are a criminal defense attorney in Austin, Texas, you need to go pull this stuff up right now. And you can, again, insert your city in here. In the city of Austin, they have this thing called Crime Reports of 2017. This is a report in Excel spreadsheet format of literally every single police call for service in the city of Austin in the year 2017. Now, what does this information actually look like? Well, first of all, when you click through it, you can get a little map, and it has these little orange dots, and I know it's a little hard to see it, but every one of those orange dots is an incident, a police report incident. The police get called to a certain address because somebody's reported a stolen car, or somebody reported an assault or something. The police come, they write a report, they issue a report number, it gets fed into the system, and you can see on a map where these calls for service are made. So this is the city of Austin in the year 2017. There's a lot of data here, okay? You can then kind of zoom in and pull in more closer, and you can start to filter for a material. Just kind of like Jerome was showing how you do a Celebrite filter, you can do the same sort of thing. And again, I know this is the city of Austin. You may be thinking, well, I don't practice in the city of Austin, but I'm telling you, this is kind of like a standard proprietary format. The city of Oakland, where I practice in the Bay Area, has this same exact formatting. So does the city of Detroit, okay, if we got anybody in Michigan. So this, if you figure out what's going on here based on these slides, the chances are pretty good you're going to be able to figure this out for your jurisdiction too. So what I did here was I filtered. I said, well, I want to reduce my window of space, and I want to reduce my window of time. I want to drill down into more specifics. And then I said, I want to reduce my crime. So I put burglary of a vehicle. So now here we're looking at, in this intersection, all the reported car burglaries in between January 1st, 2017 and January 1st, 2018 in the city of Austin, okay? And then for each one of these little dots, you can tap on it, and then you get all this information. Now, the most sort of important piece of information here, what do you guys think is the most important piece of information on this slide out of this little dot? Anybody have a guess? This is the most important piece of information. It's the incident number. This is the police report number, right? Imagine you went to the city of Austin's police department. You said, hey, I want a report of every car burglary case in 2018 to between 2017 and 2018 and this intersection. They're going to be like, we're never going to give you that information. We don't have the means to get it. Blah, blah, blah. Subpoena us, sue us, yada, yada, yada. Okay, and we've already heard all the legal challenges that people put up. Well, what if you went to the city of Austin Police Department and said, give me police report number 1, 2, 3, 4, 5, 6, 7, 8, 9. They'd be like, sure, here you go. Right? And so being able to have that incident number is extremely important and I'll show you a specific example of this in a minute. If you scroll down later down on this page, you can again start to see all the different incident numbers for all the different car burglary incidents that took place in that jurisdiction at that given time. And you can export this into a nice little handy dandy Excel spreadsheet and start to keep tabs on this stuff. Now, why do you want to keep tabs on this stuff, you may be thinking? Keep that thought in mind. We're going to get there in a minute. So I mentioned online. This is an example of how you can get police data online. We've already heard about subpoena before, so I won't belabor the point. But obviously, and there will be a specific case I'll talk about where they used a defense attorney in a CJA case very strategically used a subpoena to get information and get a suppression motion granted. And we'll talk about that case in specific in a minute. Obviously, you could use public records requests under your state public records law or FOIA if it's the federal government. This is a bit of a challenge, but it's an option. A lot of public defender offices keep really great records and have databases of this kind of information, so that's obviously a resource. And then, of course, in discovery, you're entitled to discovery. During the ShotSpotter thing, I thought it was really interesting the fact that ShotSpotter did not turn over the firecracker alert in that case. I was just thinking, like, isn't that the most quintessential Brady discovery? Literally an alternative explanation for the crime that's exculpatory. I can't believe that wasn't produced by the DA. Well, I take it back. I can absolutely understand why it wasn't produced by the DA because it's exculpatory. But nonetheless, you have to think through if your state has really robust discovery law, how you can use the discovery statutes to get what you're looking for. So we talked a little about getting the data. I said I promised I would give you 3 reasons why you want to get the data and how you could use it. So here are the 3 things we're going to talk about. Number 1, we're going to talk about challenging a high crime area designation, how we can use data to do that. Number 2 is to debunk intercrime correlation claims. We're going to talk what I mean by that in a minute. And then finally, about how to raise selective enforcement and selective prosecution challenges under the Fifth Amendment. So these are less Fourth Amendment claims and more Fifth Amendment claims. So let's start with high crime area. I practice in the Ninth Circuit, so I think the Ninth Circuit has said it, actually before we get to the Ninth Circuit, the Supreme Court has said, look, the cops can rely on the fact that a particular area is a high crime area in deciding whether there's reasonable suspicion to pull someone over to do a Terry stop. provided it's justified by other circumstances. So that was in Illinois versus Wardlow. And if you remember in that case, the guy just ran from the cops. He didn't really do anything else, but they said, well, it was a high crime area, plus he ran, so thus there was reasonable suspicion. And the Supreme Court said, yeah, that's totally fine, provided it's actually a high crime area. So unsurprisingly, the cops use the phrase high crime area all the time. And I'm sure you've seen a police report that says, I was patrolling in this neighborhood. This is a known drug trafficking corridor. This is a known area of high crime activity. And this is a really interesting law review article. And I'll keep my academic jokes to myself because we have academics here that analyzed stop and frisk data from the NYPD and assessed, what was the most common reason given by NYPD for why they stopped a particular person and did a frisk. And of course, the number one reason was it was a high crime area. And of course, we've already talked about, this has already come up, but high crime area, this can really just be a proxy for race. And that's not me saying it. This is the Ninth Circuit saying it. It is a federal appeals court 20 years ago saying, hey, by the way, just be really careful, cops, with how you use the phrase high crime area. Because that could be a proxy for race. We need to be sure we're talking about a true high crime area, not the black neighborhood or the Latino neighborhood or the Arab neighborhood or whatever it may be. I really like this language, the idea that there has to be more than just war stories to establish that a place is a high crime area. They have to look at the specific data underlying that assertion. So here, let's talk about a specific case where that underlying data was used to challenge a high crime area. This case is called U.S. versus Conor Lee. This was a case in the federal courts out where I practice in the Northern District of California. It was handled by a very good CJA attorney. And so in this case involves the city of Berkeley. I know we've got some Berkeley folks in here. So Berkeley, California police are patrolling San Pablo Park. Okay. They claim that this is an area that is, quote, commonly frequented by individuals possessing firearms and engaging in drug dealing. That's what they say in the police report. This is the actual intersection they're talking about where the crime took place. And I, a couple of years ago, I did a Zillow search for what is the house prices. This is in April 2018, so pre-pandemic, 30% markup on housing. And so, this is like an area like $900 to $1 million homes 4 years ago pre-pandemic. So I can't even imagine how much money it costs to buy a house there now. Anyway, this is the area that the Berkeley police claim is an area that is highly frequented and often by gun-toting drug dealers. And basically in this case, it's very similar to Wardlow. The client is walking, he sees the cops, he does what a lot of people do for good reason, I might add, which is he just sees them and he just starts running like as fast as he can. And so they're like, well, we'll chase him then. And they chase him and they chase him into a house and they basically tackle him and arrest him. And they find a firearm and he's a convicted felon. It's a felon in possession case. And really the legal issue, his attorneys file a motion to suppress saying, there's no basis to detain him. Just because he started running when he saw the cops is not reasonable suspicion of criminal activity. It may actually be a survival mechanism. And so, the legal issue is, was there a reasonable suspicion to stop him? And that really turns ultimately, because all they saw was the running, which by itself is not enough, because that's totally innocuous. So it really came down to, is the area a high crime area? And that was the legal question in the case. And in that case, the CJA attorneys used a Rule 17C subpoena. Again, they asked for it. It was the motion of quash was filed. It was litigated and briefed, and I can get access to the briefs if you want them. And ultimately, the district court in that case agreed to issue the subpoena to the Berkeley Police Department to get their data, because at the time of this case, the Berkeley Police Department did not have this data online. I don't know if they have the data online now. I think today, and depending on your municipality, you may not need a subpoena to get this information. You may be able to get it just doing an online search like I just showed you. But here's what the legal issue comes down to. Is it a high crime area? And really the question is, how do you figure out what's a high crime area? And this became a real source of contention. And I think this fits really nicely with what Kathy was talking about. What is a successful dinner? My kids also would think a successful dinner is they got Nutella, And to be fair, I also would think a successful dinner involved Nutella. My wife and I would also think a successful dinner involved my children eating vegetables. And so, again, I think it's the same sort of thing. There was a dispute. What's a high crime area? The government, the U.S. Attorney's Office said, well, this is how we're going to divide the area. The city of Berkeley, which has about 120,000 people in it, has a huge university. The city of Berkeley has 8 districts for their city council. So we'll treat area as the 8 districts. And San Pablo Park, where this arrest happened, it is in the top third, or it was 3 out of 8. So I guess, within the top half of incident reports and violent crimes. And it was number 2 out of 8 for drug crimes. And so it's a high crime area. Because if you look at the entire city of Berkeley as a whole, and you look at it by district, this is one of them. This district, the district this park is in, has more criminal activity than the majority of the other districts in the city of Berkeley. So that's what the U.S. attorney told the judge. That's how you figure out what a high crime area is. The defense said, no, that's way too broad of an area. Area really should be much more circumscribed. And so we think that an area is the 6 blocks near the park. And in the 6 blocks near the park in 1 year, there were 13 drug-related arrests. Well, this is a city of 140,000 or 120,000 people. That's not really a high crime area. That's not 13 arrests in a year is not that many arrests. And actually, in that case, the district court agreed with the defense. And it said, yeah, you can't just sort of, compare one district to another district, because then every city will have a high crime area, because whichever district is number 1 will be the high crime area in that city, even if that city overall has a very low crime rate more generally. Now, of course, what goes without saying, and what we have not talked about, I hinted at it at the beginning, and Kathy sort of hinted at it, and other speakers have hinted at it, there's obviously a lot of problems with how crime gets reported, right? Not every crime is reported. Some communities report crime at higher rates of their proportion of the population. Some communities underreport crime. Some crimes are underreported. Some crimes are overreported. So do not take this to say that crime reporting data is the gospel truth. What I am saying is, well, if they're going to use it, and if we have access to it, we might as well be creative in what we do with it. And so I want to be really clear about that. So again, the district court in this case says, no, you can't compare one district to another district, then every district will have a high crime area, and that's, not feasible. Instead, we're going to kind of look at it in a more circumscribed area, and 13 arrests in 1 year is that's not really a high crime area. And since it wasn't a high crime area based on data, not because the cops said it was a high crime area, well, non-high crime area plus the guy who runs from the cops, that's not reasonable suspicion. He shouldn't have been seized. The search is a fruit of that seizure. The whole case is thrown out. So that's one example of how you can use data in that way. A second way is to debunk what we call intercrime correlation claims. So what's an intercrime correlation claim? Here's an old case out of the Ninth Circuit that said a suspect caught possibly in the act of committing a nighttime burglary is more likely to be armed. Statistically, this is actually incorrect by the DOJ's own statistics, which found that actually only 7% of burglaries involved any violence, period. And of that percentage, a subset of those involved a firearm. So actually, the Ninth Circuit is flat wrong, right? But this is the holding of a Ninth Circuit case, that anytime you try to challenge this, the government's going to say, well, Ninth Circuit said that it's a reasonable inference to draw. And we see this all the time. Here's another one, again out of the Ninth Circuit. They suspected this guy of dealing drugs, so it's not unreasonable to believe that he might be armed. So again, drawing a correlation between, if you're selling drugs, you probably have a gun. Or at least it's not unreasonable to believe that he had a gun. This is out of an old police report that I had, which it said exactly, and I know you probably can't read it, so I won't belabor the point, but basically said the same thing. In that case, they suspected my client of selling marijuana in the city of Oakland, which marijuana is legal in the state of California, right? So in any event, they say he's selling it on his front porch, and they suspected he was armed. Now, he was in fact armed, but that's beside the point. Because actually, if you look at the U.S. Sentencing Commission's data of sentenced defendants in federal court, actually the percentage of defendants convicted of drug trafficking, the vast majority of them did not have a firearm. In fact, at its peak, and this is as of 2019, so it's a little bit old, but basically at its peak, it was around 18 to 19% of defendants in a federal drug trafficking case had a firearm, measured by either the existence of a 924C charge or a +2 under the guidelines for using a gun. So that means actually more than 3/4 of federal drug trafficking cases don't have a firearm. And of course, at least conceptually, federal drug trafficking cases are, in theory, not necessarily in my home district, but in theory are supposed to be more serious than your garden variety drug dealing cases that you're going to find in state court. And you would think there would be more guns in the federal ones because the feds have decided to swoop in or because there's a higher quantity of drugs. And that's not actually borne out. And that's, this is as of all drugs. But if you look at marijuana trafficking specifically, it's actually even much lower than that. It's more like 10%. So again, this is another example of how, there's this idea that these two things are correlated, but we can actually quantifiably prove that that's not necessarily the case. Now, I mentioned the city, going back to the police data. I've shown U.S. Sentencing Commission data. That's national data of a small subset of defendants who are sentenced in federal court. So it's going to necessarily be a little restrictive. Well, again, this is an area where you could use this open police data to kind of make that same point without having to go to the U.S. Sentencing Commission. So, for example, in the city of Austin example, when you're looking at the number of crimes, you can pick more than one crime. So you can control by a geography, by an area, by drug trafficking and firearms, and look for case numbers that have both, meaning the cops arrested someone, wrote a police report where that person was arrested for both some form of firearm offense and a drug trafficking offense. And that's how you can prove it. And if your answer is, of the 100 drug trafficking arrests on this block in 2018 in the city of Austin, only 3 of them had a firearm, well, there's your answer. That actually there is not a strong correlation between drug trafficking and firearms. And again, this is another example of how we can use data to kind of make the point and challenge this. If the cops are going to use the data, we're going to use the data, at least until we can reform and get rid of all the bad data. And then the final point I make, and we've only got about 5 more minutes before we can take questions, is to investigate selective enforcement and selective prosecution claims. So what I've primarily been talking about is the Fourth Amendment, your right to be free from unreasonable search and seizure. But of course, you also have our clients and all of us have a Fifth Amendment right to due process and to not have the law selectively, or to have the criminal law selectively enforced on the basis of race. Unfortunately, the Supreme Court has made it very difficult to present one of these claims. And usually the way these kinds of claims are presented is the defense will make a motion for discovery on this claim to say that, hey, I'm getting prosecuted because of the color of my skin, and some other person who committed the same crime but who is not the color of my skin did not get prosecuted for the same crime, and the only difference between the two of us is the color of my skin. What the Supreme Court has done, though, is they've made it very hard to present one of these claims, just even at the discovery stage. And we're not even talking about getting your case dismissed. And what they've said is you've got to show evidence of discriminatory effect and discriminatory intent that similarly situated defendants of other races could have been prosecuted but were not. And not only do you have to make that kind of high showing, you have to make that showing on the basis of your specific prosecutor's office or police agency. In other words, like national anecdotes that African Americans are arrested at a higher rate than white folks as a percentage of the entire population, like as a national issue, doesn't cut it. You got to show the San Francisco Police Department is doing this, or the U.S. Attorney's Office in Chicago is doing this. So the standard is high, but there was a couple cases in the Northern District of California litigated by the Federal Public Defender's Office and a bunch of CJA attorneys there where they actually were able to make the showing. So this is a very interesting case. And then I'll end here and we'll take questions involving basically Operation Safe Schools. So this was a joint basically operation by the DEA, the ATF, and the San Francisco Police Department to crack down on drug trafficking in the Tenderloin District in San Francisco. Is anybody here familiar with the Tenderloin District of San Francisco? Yeah, if you ever read like the national news about San Francisco, they always talk about how the Tenderloin is like pretty bleak. It's like an area where there's a lot of drug sales and a lot of drug use, and so it's a pretty rough neighborhood in the city. It is also like right where the federal courthouse is and where City Hall is. So it's sort of like you kind of get two parallels there. In any event, so in this operation, what they decided to do is they said, we're going to crack down on drug dealing in the Tenderloin. And what they ultimately did was they arrested 37 people federally with, basically hand-to-hand drug sales in the Tenderloin. Here's a picture, on a map of what the Tenderloin looks like. It kind of goes through it kind of starts at the western end of Union Square, and then kind of cuts until you get to Van Ness, which is a major corridor, is basically Highway 101, will take you to Golden Gate Bridge. Now, here's the key about the Tenderloin, and here's the key about how the prosecutors charge these cases. These are small-level drug quantities, and I don't know how many people are federal practitioners, but most federal drug crimes have a mandatory minimum. But if you're dealing with real small-level quantities of drugs, you don't tend to get the mandatory minimum unless you can show that the drug dealing is within 1,000 feet of a school zone. Because under federal law, if you are dealing drugs of any quantity within 1,000 feet of a school zone, there's a 1-year mandatory minimum sentence. So that's different than the quantity-based mandatory minimums that are triggered, 5, 10, and extra if you have priors, based on higher quantities of drugs. So here's the key about the Tenderloin. The entire Tenderloin is bounded by school districts and school zones, so any operation focused on the Tenderloin is going to necessarily implicate a 1-year mandatory minimum sentence. And that's also important because the federal government's decision to prosecute people for small hand-to-hand drug sales in the Tenderloin versus the San Francisco district attorney, who the current San Francisco district attorney used to be a public defender, those guys in state court are not getting a 1-year mandatory minimum. They get put into drug court and they get their case dismissed. But in federal court, there's no drug court in federal court. And if you got a 1-year mandatory minimum, your guy's going to the BOP for 1 year, regardless of his equities. So the federal government's decision to intervene is very serious and has big implications for the defendants. So I said 37 defendants were charged. Every single one of those defendants were African American. Now, I mentioned that San Francisco is a city that, like Austin that we've shown, that has all this open data online. And so a bunch of paralegals from the San Francisco FPD's office went, downloaded all the arrest data, exported all of it to a PowerPoint, went and pulled out all the drug trafficking arrests in the Tenderloin over a certain period of time, got the incident numbers, faxed the request to the San Francisco Police Department, say, give us all of these incident numbers, got all the incident reports, then went to San Francisco County Superior Court, the state court, pulled up all the cases in the San Francisco state court. Let's compare who went to federal court, who went to state court. Well, what did they find? In federal court, it was 100% of defendants were charged were African American. In state court, it was 61% were African American, 25% were Latino, and about 11% were white. So, I don't need anything more than that just by itself to show, well, there's a problem here, right? It's transparent on its face. But they did something else. They hired a statistician to calculate what's called a Z-score. I'm not even going to pretend to tell you how a Z-score works. What I will tell you is a Z-score is a measure of the probability that something is caused by chance rather than by deliberate action. And the higher your Z-score, and generally a Z-score higher than 1 is considered high, a Z-score higher than 1 is deemed to be, the result is deemed not to be because of chance. It is because of some sort of deliberate action. So the statistician found a Z-score of 4.75, which is like through the roof, effectively, which means that statistically speaking, this is not random. So this was all presented to the district court judge, and the judge found discriminatory effect and intent, and allows discovery. And then, like in the shot spotter situation, nobody got any discovery because everybody got their case dismissed because the U.S. attorney didn't want to produce discovery about how the SFPD made these decisions. Now, unsatisfying as an attorney and as an advocate, but obviously fantastic for your client who's not going to go to prison for a year for a hand-to-hand drug sale captured on video. But this is a third example of how we can use this data. It takes a lot of reverse engineering and work, but this is how you can use that data. So, do we have time for questions? We do have time for questions. So we've got maybe about 6 or 7 minutes, right? Okay, for questions. So, and as you're gathering your questions, and please ask them. Again, I hope you saw that, look, we've been spending this whole time talking about data, the problems with it, and to swat it away. But I'm also saying we got to have a holistic approach to this, right? That if that data is there, we should also be trying to use it as a sword, also while we're also trying to, swat it away and point out all the problems with it and the challenges with it. So with that, I'll leave it open for questions, and I'll repeat the question, or Jumana will repeat the question. Yeah, go ahead. The gentleman in the back.
How do we combat the high crime designation if the agency is not participating with the police data initiative?
So I think that's challenging. But as I mentioned, I think there are a couple ways you could do it. So number one is you could subpoena the data. In the case that I talked about specifically, that involves the city of Berkeley. The defense attorneys in that case used a subpoena to get the data. So they did not get the data online. The city of Berkeley is this pretty small police department, and the university has its own police department. So they did not have their data online, at least at that time. So the defense attorney subpoenaed it, but also, part of the process of the subpoenas, you got to show the judge, look, this is why I need it. And so the defense attorneys had filed a motion, had laid the legal issue out and said, look, it all comes down to high crime area. And we cannot just rely on the anecdotes of the two patrol cops said, well, of course, it's a high crime area. Make the department give us the data so we can prove it. And I'll add, real quick, for federal practitioners, Rule 16, Federal Rule of Criminal Procedure 16 says, on the defendant's request, the government is obligated to produce any material that is, quote, relevant to preparing the defense, end quote. And at least in the Ninth Circuit, that has been interpreted by the Ninth Circuit to include evidence that is relevant to raising a suppression motion. So it's not just evidence that's relevant to a trial issue. It's not just a matter of guilt or innocence at trial. And I think this is similar to the point made earlier about Florida v. Harris that, if the stop is based on the dog, we get evidence about the reliability of the dog. Well, if the stop is based on it being a high crime area, we get evidence to see how they're coming up with that determination. And so I think that would be the way you would make that pitch.
Hi, I've got a case with a selective enforcement claim pending right now, and I'm going to come bother both of you extensively sometime in the next 24 hours. But I just wanted to throw a thought out for everybody in the room as we're listening to Hani and Jumana talk about this, is that thinking about selective prosecution versus selective enforcement, there's a really wonderful case from the Seventh Circuit, Conley, Conley, from 2021, that talks about that we should be pushing for, I'm interpreting as we should be pushing for different standards for selective enforcement claims as opposed to prosecution claims. So as you're taking all this amazing information and using it, go to that case, start litigating that issue, hopefully we'll win.
I'll say real quick, and then I'm going to turn over to Jumana. The Ninth Circuit has a case that also reached the same result, that the standard is higher for a selective prosecution claim, which is aimed at the prosecutor's office, versus a selective enforcement claim, which is aimed at the police department. And I also think that we are in a time where I think judges are going to be more receptive to these challenges. I mean, they watch the news, they see what's going on. So yeah, I think that's a great point. Thank you.
Yeah, and just a minute to wrap some of these things together. If you sort of look at the various things that we went through today, and one of the reasons we invested so much time and energy into this predictive policing task force, so like I said, it wasn't about any one company or one particular program. But for our task force members, and Bill Wolf is also in the audience, who spend a lot of time, right, traveling, reading, talking to people, it's because all these things are sort of wrapped into each other. So when you think about this, it pulls in the issue of trade secrets, right? And algorithmic transparency, and the questions of how do these things work? How are they determining, what weights are they using to determine what neighborhood to go to or who they should be policing? It brings in questions of, again, what issue, when you come to issues of selective enforcement, I think, so basically it brings in issues that have gone on all day, but what I want to tell you is if you think about this, your criminal defense lawyers, your job is to get creative, right? You don't have the resources of the government. You don't have access to everything they have access to, but you're very good at getting creative. And so when you think about what Debbie's doing, what Hanny is proposing, all of this is getting creative. And so I encourage you to not be put off by the tech piece, because there are experts for that. You can call us for that. But at the same time, take these opportunities to think about, well, if they are now saying, the computer told me to go and police this person or police this neighborhood, can we now litigate intent back out of the 14th Amendment analysis? Because, either you're going to say, yes, the computer's racist, or there's no intent. And therefore you have to look at, what are the outcomes versus the intents. Looking at cases like Carpenter, right, which was looking back at the qualitative and quantitative difference of what's available to law enforcement. When you think about that qualitative difference, is there a Carpenter hook that says you can't use these platforms? You can't use these like big data gathering platforms to analyze and put it out, because now what used to take them days, months, weeks, in the dark ages when they had to scroll through and look for themselves is happening in an hour, in a minute, in a day. And this has now, fundamentally changed what's happening to our clients. I think basically what I want you to take from this is all of this is building on each other, and we have to get real creative about how to counter it. And so I know I'm going to do this oddly, but since I'm about to introduce our next speaker, it runs right into each other, because she's going to talk about sort of what's happened since Carpenter and how do we think about that. But my sort of enduring message is use the data as a sword, use every decision as a sword, use every creative new way to start to go at this, because they're never going to stop coming out with a new name, a new program, a new company, a new version of the same old racist policing. And so we've got to get creative with how we respond to it.
And I think that's our time, so thank you.